Welcome back. Now, attempts by a controversial businessman, Mthunzi Mdwaba, to obtain a forensic report that was cited in his removal as chair of Productivity SA have been dealt a blow at the Pretoria High Court. The court dismissed the application with costs. The forensic report was commissioned by the Department of Employment and Labour. The court ruling is part of the ongoing court battle between Labour Minister Thulas Nxesi and Mdwaba to set aside the 5 million Thuja capital unemployment insurance fund job creation contract. The matter has now moved to the main application, which was submitted by the minister in an attempt to urgently deal with the matter and clear his name.
Well, the minister is very pleased with the dismissal of the matter, the interlocutory application from the respondent, Mr. Mdwaba, with cost. He's very pleased with that. We always maintain that we have served documents on them properly from the onset. And it just so happened that they were giving us the runaround, as we mentioned last week. And clearly these delay tactics of theirs now are at an end. And we're happy about that. And we're happy that the main matter is now in court. As I mentioned last week, this matter is of high public interest. And it's also in the interest of the minister and his reputation and his social standing that this matter gets ventilated and that it gets brought to finality.
We also understand that the legal counsel said that introducing this interlocutory application was a delay tactic to further deviate from the main application. So why do you think they would do that if, we understand that there's 5 billion hanging in the balance, and I would understand that that's a lot of money that Mr. Mdwaba would want to get the ball rolling?
Well, we can speculate as much as we want to, but it could also be that they are playing politics, and that's why they're trying to drag this thing out for as long as possible, in hope of a resolution of some sort that would go in their favor and that would be settled outside of the court.
And one of the arguments also raised by the minister was that Mr. Mdwaba has raised defamatory comments based on the media platform. And one of the reasons he said is that in his affidavit was that Mr. Mdwaba is saying that he will no longer be cabinet minister after this year's election, and that he's using this so-called 10% or 500 billion as an attempt to heist the public funds or the government. Do you believe that he has any allegations or any proof of what he's saying?
Well, the proof of that needs to be tested in court, and that is why we are ventilating this matter to see if he has any evidence to back up or substantiate the allegations that he's making in court. Well, and that is why we are here today to ventilate this matter, and it doesn't seem like he has any proof, but we want him to come forward with the proof that says or indicates that the minister is corrupt and the minister has done all the things that he's been going around on public platforms to go and say. And I think it's important for me to indicate very, very clearly that the correct thing for Mr. Mdwaba, particularly because he's a person of the kind of social standing that he has, would have been to come to court, to ask the court for a declarator to declare that his contract or the Thuja Holdings contract is valid, lawful and enforceable. That would have been the sensible thing. And I think for someone of his social standing, it is unbecoming. It baffles us why he would go on an elaborate smear campaign in the media as opposed to being also a lawyer himself. Not coming to court to come and deal with these things on the appropriate forum or platform and have the matter then ventilated there, so that if he really has a valid contract, that his contract can be declared valid and so that it can be implemented or enforced as he wants it to be.
Mm-hmm. And then just lastly, we understand that one of the reasons why this contract was rather terminated was because it was in contravention of section 54(2) of the PFMA Act, and we understand that it's because that the Treasury had to submit the documents to the DG had to submit to Treasury, and then the Treasury had to submit to Executive Authority, and that did not happen. Had it happened, it was going to be seen as fruitful and wasteful expenditure. So we just want to understand, is that true? And now that we're arguing the merits of the case, do you see that you have a chance of winning the argument?
Listen, the facts speak for themselves. Everyone knows that is what happened. This matter was concluded at a level that, in terms of the PFMA, it should not have been concluded. And we want the matter to be ventilated, to finality, and at the same time we want the court to pronounce on this, whether it is unlawful or not. We know what the facts are and that are before us, but we want the court to pronounce on this so that we can, bring an end to the public, the defamation rather that's been going around, and that Mr. Mdwaba has been behind all this time.